Before we get into today's update, I want to talk about something. Normally when I cover an update, I see things pretty black and white. Who's in the wrong, who's in the right, who's trying to be sneaky or play dirty, and who's doing their honest best. On the subject of Buster, it's kind of hard to see it just in black and white, because a part of me feels bad that Buster has endured years of defamation. There's no doubt he has. But on the other hand, there seems to be a little sneaky playing dirty in this lawsuit. So this one is a little bit conflicting. Let's get started. This is Legal Updates with Cassidy. Buster Murdaugh is suing everyone. Part 2. The Fight for Jurisdiction. Welcome. It's about Buster's lawsuit against Netflix, Warner, and multiple other defendants. I'll link my first podcast about that in comments. But since that last update, the defendants as a whole have requested that this case be removed from the Hampton County Courthouse and into the federal court. This was filed by John Lay, who you might remember as one of the co-receivers who handled Alex Murdaugh's assets leading up to the trial all the way until the money was divided earlier this year. The second attorney noted was Natalie Spears of Chicago, and this was filed on September 9th. We find this request on the first page where they ask it to be held in the U.S. District Court of South Carolina, Beaufort Division. The introduction has 5 points. The first one is just a summary that this case arises from 3 documentary series that reported on the Murdaugh situation. Point 2 is about the fact that all of the defendants are incorporated and have principal places of business outside of South Carolina. And as we'll see, they're not even all from the same state. So the very fact that it's multiple states is grounds for federal diversity jurisdiction. Point 3 has 2 important parts. They say that adding Michael DeWitt, the only local person, is a blatant attempt to avoid federal jurisdiction. They call the claim against him meritless. They point out that he was actually misquoted and that he is the only individual that's being sued, with the rest all being corporations. So the second point, they say it's a blatant attempt to manufacture a cause of action where none exists. Point 4 is that his joinder to this case was fraudulent anyway because what he actually said in the series has no viable cause of action that could be asserted against him. The document then moves on to procedural background. Points 6 through 9 summarize how these different documentaries came about, with point 10 saying how the complaint alleges that DeWitt, acting in his individual capacity and within the scope of his employment with the Hampton County Guardian, that he falsely accused Buster of being involved in the murder of Stephen Smith. The issue in point 11 is they say the complaint fails to identify specific causes of action, that it's a broad assertion, that instead they broadly assert conclusory allegations without articulating claims with sufficient clarity to allow the defendant to frame a responsive pleading. This is called a shotgun pleading. This type of pleading violates South Carolina and federal law code. They're called shotgun pleadings or kitchen sink pleadings, or throw it against the wall and see what sticks. The 11th Circuit Court set up 4 defining characteristics of what a shotgun pleading is. One is where each count adopts the allegations of the preceding counts, so it's kind of keeps listing the same basic allegations over and over again, combining them. 2, complaints that are vague or have immaterial facts, or they're not associated with a specific claim or particular cause of action. 3, complaints that fail to set out each claim for relief or cause of action into a different count. And 4, complaints asserting multiple claims against multiple defendants without specifying which defendant is responsible for which act or omission, or which claim is being brought against which defendant. They're disorganized, they're unclear, they're vague, and judges hate them. We're going to move on to point 15 on page 5. That says that venue for removal is proper in this district and division because the Beaufort Division of the District of South Carolina embraces the Hampton County Court of Common Pleas in the 14th Judicial Circuit in the state of South Carolina, the forum in which the removed action was pending. So originally this was filed for the Hampton County Court, and the Hampton County Court belongs to the Beaufort Division of the District of South Carolina. as we see on this map that separates which parts of South Carolina go to which federal court. Of all the ones here listed on the map, Beaufort is one of the very few that doesn't have their own federal courthouse. It meets at the Charleston courthouse. And now let's talk about why federal court is the proper jurisdiction. And we hear a term we heard just a moment ago, diversity jurisdiction. That has to do with the defendants being from multiple states, as in this case. One of the other criteria is the amount of money that the lawsuit is for. If the amount exceeds $75,000, that's one of the deciding factors. And we'll cover that in just a moment. Point 18 is about improper joinder, misjoinder, what used to be called fraudulent joinder. And this is the main accusation they're making about Michael DeWitt, that he was inappropriately or misjoined to this case simply to allow the case to take place in Hampton County. But moving on to the amount in controversy requirement being met, the lawsuit has not specifically said an amount, but based on some ideas here, they do expect it to be over $75,000. When a plaintiff has not specifically given the amount, a notice of removal such as this document need only include a plausible allegation that the amount in controversy exceeds the jurisdictional threshold. And they give the reasons why this allegation is plausible. For one, we're talking about a number of different defendants. These are giants, streaming platforms, and let's be real here. Suing this many people, these types of defendants, $75,000 isn't even going to make a dent in the legal fees alone. It's a pretty safe assumption that this is a suit for much more than $75,000. And now back to the idea of diversity jurisdiction. This portion goes through each company that's being sued, where they're incorporated, and where their principal place of business is. We see that Blackfin is organized and operating under the laws of the state of New York. Warner Brothers Discovery is organized and exists under the laws of the state of Delaware, and its principal place of business is the state of New York. Warner Media is both organized under the laws of the state of Georgia, and Georgia is also its principal place of business. Defendant Campfire exists under the laws of California, and it is its principal place of business as well. Cinemart LLC is organized under the laws of the state of New York, and its principal place of business is New York, but one of its main members resides in New Jersey. Netflix was organized and exists under the laws of Delaware, but its principal place of business is in California. Gannett was organized and exists under the laws of the state of Delaware, and its principal place of business is New York. Michael DeWitt is the only citizen that's from the state of South Carolina. And point 34 adds that DeWitt must be disregarded for the purposes of this notice of removal because he has been fraudulently joined in this action. Point 37 goes into this a little bit further, saying the complaint fails to articulate specific allegations against DeWitt and does not allege facts supporting the basic elements of defamation. They also point out that there's no possibility whatsoever that the plaintiff could recover against DeWitt. And then we see some cases cited about fraudulent joinder. Now this term has been updated in a number of courts to improper joinder because it requires neither fraud nor joinder, and it doesn't reflect on the integrity of the plaintiff or counsel, but it's a rubric that's applied when a court finds either that no cause of action is stated against a non-diverse defendant or, in fact, no cause of action exists. And this kind of joinder, its sole strategy of purpose is destroying diversity and keeping litigation in a selected state court. And they're saying in this case that the complaint does not contain allegations that entitle it to relief against Michael DeWitt. Therefore, he has been fraudulently joined. They then go on to cite some cases that back that up. And here's a quote from one of them. It says, "Such jurisdiction is based on the dual goals of avoiding local prejudice and guaranteeing the vindication of federal rights. First Amendment cases involve the application of federal constitutional principles designed to resolve the inherent tension between free speech and privacy rights. In addition, defamation cases often concern media criticism of local citizens, necessitating a forum free of local prejudice." Part D says plaintiff has no colorable claim against DeWitt for defamation. A colorable claim is a plausible claim, but it's strong enough to have a reasonable chance of being valid if the facts can be proven in court. So basically they're saying this claim against DeWitt has no plausible or reasonable chance of being valid. Because 1, the plaintiff must prove a false and defamatory statement of fact. 2, an unprivileged publication to a third party. 3, fault. 4, either actionability of the statement irrespective of special harm or the existence of special harm caused by the publication. Then it spends some time talking about these accusations that were leveled at Mr. DeWitt and how some of the quotes they have in the complaint were manipulated in a way to sound worse than they actually were. For example, in the complaint they said, "And when I first covered this, I remember saying this could be problematic, but seeing it in its whole context really is a different story." So for one, they say, "We were hearing all these rumors about a possible Murdaugh connection," and then they say, "There's some truth to it," which does sound like he's defaming Buster here. However, as this brings out, what he actually said, within 1 month of his body being found, we were hearing all these rumors about a possible Murdaugh connection. And I've learned as a reporter that if you hear the same rumors from different groups of people wherever you go, it's either a very good rumor, that's the part they left out, or there's some truth to it. So we did our story in the Thanksgiving 2015 paper. That's quite different. He says, when you hear rumors, it's either a good rumor or there's some truth to it. But they quoted him just as saying, there is some truth to it. Very, very different. The complaint also listed something he said, saying I began to have a bad taste in my mouth about the members of the Murdaugh family, as many people in the community did. But what they failed to communicate in the complaint is that when he said this was not in the segment where he was speaking about the Stephen Smith murder. It was an entirely different part of the series, unrelated to Buster, so it doesn't belong in this complaint, is what they're saying. Point 48 points out that Buster is not mentioned anywhere in the entire passage, and DeWitt never specifically references Buster. Point 49 says that DeWitt's comments were hearing all these rumors about a possible Murdaugh connection. We said a prominent, well-known family was rumored to be involved, so that there's unspecified involvement of the Murdaugh family, and that this is not specific to Buster. So it cannot support the claimed defamation that Buster is guilty of murder. Because the series went in great detail of the misdeeds of other members of the Murdaugh family. It was never specifically just about Buster. So that further makes his remarks even more vague, and therefore shotgun. Another statement they quoted him on was that he began to have a bad taste in his mouth about the members of the Murdaugh family, as many people in the community did. Again, no way refers specifically to Buster and does not refer specifically to the Stephen Smith murder. He was speaking about the reputation of the Murdaugh family in the community as a result of Alex's behavior. Alex is the infamous disgraced lawyer. His actions are central to the series. What's more, he's been convicted on all of those counts. He's also somewhat protected by being a journalist. He was simply sharing what he heard from multiple sources and what he reported. He was not asserting truth to any particular statement or rumor, much less to one specifically accusing Buster of being involved in murder. It was a subjective view, an interpretation, a theory, and that also makes it not actionable. Also, him saying this about a bad taste in his mouth is a subjective opinion. And then it lists other statements made by other journalists where they gave their opinions. And point 54, also very important, it is clear from the context that DeWitt was not stating any facts of which he had personal knowledge, but rather speaking as a local expert about what he'd learned about the law enforcement investigation and what he'd heard from others in the community. Both his comments and the series as a whole are focused on the power and influence of the Murdaugh family and how that may have impacted the course of justice in multiple situations, not making factual claims about who killed Stephen Smith. And 55 points out the truth of these rumors. There were rumors that the Murdaughs were connected in some way to Stephen Smith's murder. There's actual audio out there of an officer who was investigating it and tracking down the rumors. There were multiple people who gave Buster's name. In the end, it was not traceable to him. It was nothing more than rumor, but it was factual that those rumors were being spread throughout the community. There was also the point where the case was reopened. As they said, based on what it learned in the investigation of the murders of 2 members of the Murdaugh family. And we all heard that. We thought that there was something that was going to be some aha moment, something that was found on a tablet or a phone that was going to place one or more of the Murdaughs at the scene of this murder. 57 tells us that under South Carolina law and laws of the states where other defendants are located, fair reports of official acts, reports, and records are privileged and cannot form the basis of a libel claim, and that this privilege is what encourages the media to report regularly on government operations so that citizens can monitor them. Point 59 says that these allegations against DeWitt serve no purpose other than to destroy diversity jurisdiction. With 60 saying because plaintiff has not alleged any facts that could potentially give rise to colorable defamation claim against DeWitt, he is a sham defendant and removal is proper. And the conclusion summarizes that all again, and as I said, was put forth by John Lay and Natalie Spears. And they are listed as attorneys for defendants Netflix and Cinemart. Then on September 10th, there is another notice of removal. It matches a lot of the same language. This was filed by Merritt Abney and Wilkie Farr and Gallagher. These are attorneys for defendants Blackfin, Warner Brothers, Discovery Inc., Warner Media Entertainment Pages, and Campfire Studios Incorporated. And on the same day they filed an alternative motion to sever, again filed by the attorneys for Blackfin, Warner Brothers Discovery, Warner Media Entertainment Pages, and Campfire Studios. Basically what they say is that this should be removed from this court, but if the court does decline to remove it, they're asking to be severed and not listed as defendants along with all the other co-defendants. They make a really strong statement on page 2. Plaintiff has forum shopped this lawsuit against 7 non-resident media defendants and 1 resident local newspaper editor in Hampton County, where the Murdaugh family launched its dynasty more than a century ago and has since become synonymous with power and the law. His claims arise from 3 entirely separate documentaries, 2 distributed by the Warner entities and another by Netflix, and allege that they are defamatory based on different statements published in different contexts. To land in Hampton County, plaintiff improperly attempts to lump the documentaries and the defendants together in a single case. So they're saying if we can't have this in federal, at least separate us. We're not the same company, we're not the same documentaries. They say that Buster has violated Rule 20 by improperly joining an action to determine liability for alleged defamation against the Warner defendants with an action to determine liability for alleged defamation by the Netflix documentary defendants. That they have no real connection to each other, and that the Warner defendants would suffer prejudice by being forced to defend themselves in connection with their own separate documentaries alongside unrelated statements and publications. Buster's claim against the Warner defendants stand alone, and he should not be permitted to manipulate the legal system in contravention of the rules in order to litigate them all together in his preferred forum. Accordingly, if this court rejects the other basis for removal articulated in the Warner defendants and removing Netflix defendants concurrently filed notices of removal, the court should exercise its substantial discretion to sever the distinct claims against the Warner defendants. They point out that Buster's believed to be living in Bluffton, which is actually Beaufort County. Page 5 again differentiates. These are different documentaries: Murdaugh Murders, Deadly Dynasty, Low Country, The Murdaugh Dynasty, and Murdaugh Murders, A Southern Scandal. Pages 6 through 8 give the legal standards, citing cases as proof that this is the correct way to do it. Page 10, they repeat the misjoinder. It's a lot of repetition and a lot of case citations after that. Then on September 20th, Buster asked for more time to respond. 3 days later, the defendants opposed that request for more time. And then on October 1st, Buster comes back with a motion to remand with all of his reasons why it needs to stay in Hampton County. So basically, this is just a one-page document saying that defendants cannot meet their burden for establishing fraudulent joinder. They lack any objectively reasonable basis for the removal of plaintiff's action to this court, and that the reasons will follow in the plaintiff's motion to remand to the Hampton County Court of Common Pleas. And they also ask for fees and costs. They start with saying that the Netflix defendants have not met their burden of demonstrating either one, and the first one's funny because we just learned from the defendant's motion that there doesn't have to be outright fraud. But here, their number one thing is that they haven't demonstrated outright fraud in plaintiff Richard Alexander Murdaugh Jr.'s complaint. Well, it clearly said that the plaintiff or plaintiff's attorneys do not have to have committed fraud, so I don't know why this is in here. But two, that they haven't demonstrated that there's no possibility that Buster will be able to establish a claim against DeWitt. And so because they haven't met either of these requirements, that the court should grant Buster's motion to remand. And as far as the motion to sever, they repeat the same things. Again, that they haven't shown outright fraud, which again is not necessary, and that the defendants cannot meet their heavy burden, or that it would be impossible for Buster to permissively join all defendants in this action in a single lawsuit under South Carolina Rule of Civil Procedure 20. And that since they can't point to any South Carolina law that would definitively bar the causes of action against DeWitt or preclude all defendants from being joined in a single action, and their arguments are in fact meritless and unsupported by any recognized principle of South Carolina law, Buster requests that the court grant his motion, remand the action to the Hampton County Court of Common Pleas, and award him for costs and attorney's fees incurred by defendants' frivolous removal. It repeats what it said in the complaint, that in the Netflix series, when depicting Stephen Smith's murder, there's a young man with red hair carrying a baseball bat, and they say that because the man had red hair, that it was readily ascertainable that they were depicting Buster as the killer. They also point to statements such as, everyone keeps coming up to me and saying it was the Murdaugh boys. Another statement, listening to these statements, it's pretty clear Stephen's death is intertwined with the Murdaughs. It also points to several false statements that Mr. Murdaugh was engaged in a romantic relationship with Mr. Smith and that it was Mr. Murdaugh who killed him. Now, unfortunately, these were the rumors. Like I said just moments ago, there are audio recordings. There was a police officer that did his absolute best to track these rumors down. But the fact is, people were telling him it was Buster Murdaugh. It's not defamation. It's not false that these rumors existed. These rumors absolutely existed. Some probably still exist today. The red hair, it very well could have been that they were depicting Buster by that, but here's the point. It didn't actually say it was Buster. It's really a stretch to make that actual evidence in a lawsuit. And as I said earlier, my heart does go out to Buster for being falsely accused of this. Obviously, it was never actually truly traced to him. And it would be a horrible thing to have those accusations and having so many people wonder if you did it or believing that you did it. That's terrible. But there has to be actual evidence of a law being broken. And in a footnote, they say that the Netflix defendants rely on dicta from the non-binding decisions of other federal jurisdictions in an attempt to convince the court that removal is favored in defamation cases implicating the First Amendment, assuming it's implicated at all by Mr. Murdaugh's claims. Unsurprisingly, there is no case law from this district or the Fourth Circuit supporting this proposition. The Fourth Circuit has clearly placed the burden on defendants to prove fraudulent joinder regardless of the context, and in doing so has specifically instructed that all doubts, facts, and legal uncertainties must be resolved in the plaintiff's favor. They go on to claim that DeWitt is a properly joined defendant. They say that DeWitt was named as a defendant in this action on the basis of the following statements he published concerning Mr. Murdaugh within the Netflix series Murdaugh Murders, A Southern Scandal. And then they print what he stated. Within 1 month of his body being found, we were hearing all these rumors about a possible Murdaugh connection. And I've learned as a reporter that if you hear the same rumors from different groups of people wherever you go, it's either a very good rumor or there's some truth to it. This time they put it all here. So we did a story in the Thanksgiving 2015 paper, and Sandy Smith, Stephen Smith's mother, basically appealed to the community. My son was killed. If you know something, please come tell us. We just want answers. We want closure. So we could not put the Murdaugh name in a story unless we wanted to face lawsuits. We said a prominent, well-known family was rumored to be involved. Everybody knew who we were talking about. We published the story, and we waited. People would come up to me in the Piggly Wiggly, pat me on the back, We're so thankful you ran that story. So proud of you to have the courage to do it. I mean, we did everything but put the Murdaugh name in the story, but the story did no good. And I go back and forth with this one, I really do. If it were just the first part, that it's either a very good rumor or there's some truth to it, I don't think there's a lot there, but these last few sentences, so we could not put the Murdaugh name in a story unless we wanted to face lawsuits. And the very last one, we did everything but put the Murdaugh name in the story, but the story did no good. So it sounds like he was trying to frame him up. I am bothered by this. From the first time I saw it to this rewriting of it, I am bothered by this. I don't know, this could go either way. They say that Buster does not misquote DeWitt, that the cause of action is entirely based on what he actually said in the series, and that any inadvertent omissions of any specific words or phrases in the paraphrased allegations of the complaint actually strengthen Mr. Murdaugh's claims against DeWitt once his statement is considered in its entirety. They say the Netflix series is rife with references to Buster as the individual responsible for Mr. Smith's death, and that in the 6 minutes preceding his quote, that Buster's name is mentioned over 10 times, and does depict a man with red hair that resembles Buster holding the baseball bat, and reiterates the rumors about a romantic relationship and about a murder. They say that his statements were defamatory and were sufficiently clear that they were made to inform the recipient that the statements were of and concerning Buster. They claim adding DeWitt to this lawsuit is not a blatant attempt to manufacture a cause of action where none exists, that it's not bad faith to use strategy to defeat federal jurisdiction, and that it was more than a possibility that Buster will prevail on his defamation claim against DeWitt, so that removal would be inappropriate. In order to prove fraudulent joinder, the defendants must show either that there is no possibility that the plaintiff would be able to establish a cause of action against the in-state defendant in state court, or that there has been outright fraud in the plaintiff's pleading of jurisdictional facts. That the burden of claiming fraudulent joinder is heavy, and the defendant must show that the plaintiff cannot establish a claim against the defendant. They state that if there is a glimmer of hope in prevailing, if the answer is yes, then the court lacks diversity jurisdiction. But they say that it is possible for Buster to demonstrate that DeWitt made false and defamatory statements, and repeat again that the implication was made that Buster murdered Stephen. On page 13, they say, to render the defamatory statement actionable, it is not necessary that the false charge be made in a direct, open, and positive manner. A mere insinuation is as actionable as a positive assertion if it is false and malicious and the meaning is plain. Statements, therefore, may be either defamatory on their face or defamatory by way of innuendo. Innuendo is extrinsic evidence used to prove a statement's defamatory nature. It includes the aid of inducements, colloquialisms, and explanatory circumstances. And this kind of situation is referred to as defamation by implication. So they're saying it doesn't matter if these rumors abounded in Hampton County, or whether DeWitt had found that in his experience as a reporter that pervasive rumors are often true, or whether he'd reported that a prominent local family was rumored to be involved in Mr. Smith's death. What matters is whether the defamatory implications that Mr. Murdaugh was connected to the death of Mr. Smith can reasonably be inferred from DeWitt's statements. This motion is quite long. I'm really skimming through it to find the high points. For example, they mentioned that DeWitt's statements could have led a reasonable person to believe that DeWitt was implying that Buster was involved in Mr. Smith's death. They also point out that there were things lacking in his reporting, such as that there was no evidence linking Mr. Murdaugh to the death of Mr. Smith, as well as a tip from 2015 indicating that 2 other individuals were involved, and not Buster. So by leaving out this well-known information, they say that it could reasonably understand the meaning intended to be expressed was that Buster was involved in the death of Mr. Smith. They mention how the Netflix defendants believe that DeWitt's statements are not assertions of fact and are pure opinions that should be protected by the First Amendment, but they say in fact DeWitt admits that he did everything he could to inform his readers that there was a rumor connecting Mr. Murdaugh's family to Mr. Smith's death, and that everyone knew who was being referenced in the story. And again, I have to say, that last little bit, those last several sentences that he said, do imply that. I mean, even the brag about people approaching him in the Piggly Wiggly and patting him on the back. It was almost like he was bragging that he had gotten people to think that it was Buster. And they have another good point where they mention how the Netflix defendants argued that since DeWitt's statements didn't single out any individual members of the family when speaking about the Murdaugh family, they cannot be ascribed to Mr. Murdaugh. However, all that was left of the known Murdaugh family, because Buster's mother and brother were both deceased, his grandfather was deceased, his grandmother had dementia, what's left is a pretty small circle of Alex, Buster, Randy, and John Marvin. And then they mention cases where group size like this plays an important role in the analysis of a situation, saying that the family was not so large that it would have diluted defamatory accusations' impact upon Mr. Murdaugh, nor is the family so large to be practically indefinite. Murdaugh's position in his family is highly visible, through no voluntary choice of his own, due to the extensive reporting that has occurred regarding the controversy surrounding this lawsuit and Mr. Murdaugh's father. They say his statements do not fall within the fair report privilege, because that protects fair and impartial reports, but that DeWitt's statements do not concern any official acts, reports, or public records, but they are merely republications of rumors. It again asks for costs for attorneys for this frivolous removal of this action. And this document is so very long, 36 pages. The original complaint was a fraction of this length. So it concludes just kind of repeating arguments that have already been made. And then it does have an exhibit that is transcripts of the interviews of Michael DeWitt. I'm not going to read them now because I don't know if they are in full here, because previously they had just put them in part. I actually plan to rewatch all of these documentaries to verify for myself what his transcripts were. As I said at the beginning, this is a troubling one. This isn't an easy black and white for me. I mean, maybe for some of you listening, but for me, I can see arguments on both sides. But it does come down to this. I don't understand the fight to keep it in Hampton County. I don't know why that's necessary. If you feel you actually have a good case, why would you care which court you're in? It's suspicious to me to keep fighting that it must take place in Hampton. I think if you have a good case, you have a good case no matter which court you argue it in. So I keep coming back to that. But both sides have good attorneys, and both sides make good arguments, and I'm glad I don't have to be the one to decide. And truthfully, I can't tell you which way I think it will go or which way I think it should go. So my head's just spinning a little bit on this one, and now I have to watch these documentaries again. But I will be on the lookout for the court's decision, and I will let you know. And until then, this is a confused Cassidy O'Connell saying stay well and stay tuned.